Everyone, thank you for joining us for our Human Rights in Practice event, New Developments in LGBTQ Rights Within the Inter-American System. I'd like to introduce first Professor Macarena Sáez, who is the Faculty Director of the Center for Human Rights and Humanitarian Law and a Fellow in International Legal Studies at American University, Washington College of Law. Professor Sáez teaches in the areas of family law, comparative law, and human rights. And she was one of the lead counsel for the victims in the first case on sexual orientation before the Inter-American System of Human Rights, Karen Atala and Daughters v. Chile. She's given her expert testimony on issues of sexual orientation and gender identity before the Constitutional Court of Colombia and the Inter-American Court of Human Rights. And especially relevant for today's discussion, she supervised a team of American University students who wrote a legal brief and participated in hearings before the Inter-American Court regarding the advisory opinion that will be discussed today. She's written extensively on gender, sexuality, and the law, especially on the issue of marriage equality, and we're so grateful that she's made the trip to be here today. We also have with us Professor Larry Helfer, as many of you know, Harry R. Chadwick, Senior Professor of Law and Co-Director of the Center for International Comparative Law. And before turning it over to Professor Helfer, I wanted to add that this event is co-sponsored by several different groups today, including the International Human Rights Clinic and the Center for International Comparative Law. Also Outlaw, the Duke Human Rights Center at the Franklin Humanities Institute, the Duke Human Rights Center at the Keenan Institute for Ethics, the International Law Society, and the Human Rights Law Society. And I also wanted to especially acknowledge Gustavo Ruiz, who initiated the idea for this event and took great leadership in making it happen today. So with that, I will turn it over.
Yep. So good afternoon, everybody. Thank you for coming today. I am going to be quite brief because I actually want to hear more about the latest advisory opinion, which I think is really a watershed development in the Inter-American system. But as someone who has been engaged on and off in advocacy on LGBT rights and international law for longer than I care to admit, I thought I would give you just a very brief kind of overview of some of the developments that have happened elsewhere in the world, some of the challenges that exist as well, and set a little bit of the normative framework and then turn it over for a discussion. So let me just start, as one always would, with the Universal Declaration on Human Rights. There's no reference to sexual orientation or sexuality or gender identity in the UDHR. Obviously, that doesn't matter. It isn't preclusive because the Declaration applies to everyone and all human beings. Nevertheless, as a document drafted in the late 1940s, there are very clear indications of, let's call it heteronormativity in the document, or at least there is some fingerprints of that. So in the provision on distinction or discrimination in Article 2, there's a reference to sex and other status. The other status is an open-ended clause, but it doesn't mention gender identity or sexual orientation, which is something you would probably see much more of if you were looking at a national legislation or in the United States, state legislation today. Also, with respect to the right to marry, referencing the family as the fundamental group unit of society. I think it's clear that if you were to ask the drafters what they thought, whether same-sex attraction or gender identity would be protected, they would have said no. I would also say that that's entirely irrelevant. International human rights law is very much, of all the kind of areas of international law, quite evolving over time. And it has been used very effectively by advocates, including my colleague, in a variety of different ways. And I want to just talk to you a little bit about some of those strategies and some of the successes, focusing a little bit on Europe, because that's where things really started in this area. And that will tee us up for a discussion, a little bit of a tour around the rest of the world, and then a discussion back in the Americas. So a variety of different vectors of LGBTQ human rights advocacy exist. These are not mutually exclusive. They are layers on top of each other. Hopefully, in the ideal situation, they are mutually reinforcing. And I think it's important to note that one needs to think about both the ways in which one can develop international norms through international institutions or regional courts such as the European or Inter-American human rights courts, and also how they apply on the ground, right? How do they actually impact the lives of LGBTQ people around the world in a variety of very different circumstances, including individuals who identify themselves differently than individuals perhaps in other countries, and where social and legal mobilization can sometimes be very empowering, but can also at other times be frankly quite dangerous, or if not deadly. So that's something to keep in mind, this interactive effect of these advocacy strategies. But I will say that the normative development at the international and regional level has been quite important. And that normative development began back in Europe in the early 1980s. So probably all of you, many of you probably were not even alive when the Supreme Court, the US Supreme Court, rejected the right of privacy applicable to same-sex consensual conduct between two men in 1986. They since have reversed that in the Laurence v. Texas case. But 5 years before the Hardwick case in the US Supreme Court, the European Court of Human Rights had endorsed the right of privacy. And that was the beginning of a set of advocacy strategies, initially within Europe, but then expanding out more broadly, starting with criminalization, and then moving more broadly beyond that to questions of freedom of expression, freedom of association, partnership, family life, and eventually marriage. So I'll just show you a few of the recent cases of the European Court of Human Rights. The court has been quite expansive in this area recently. I couldn't even list all of the recent cases that I just chose a selection of them. But what I will say about this pattern here is that so far the court has underscored that same-sex couples do have a family life, not just a private life, but they have thus far refrained from imposing an obligation on states to recognize same-sex marriage. There is an obligation to provide some sort of recognition, whether through partnership law, civil union, or marriage, but the court has not gone that far, and I think that's going to become relevant when we talk about what's happening in the inter-American system. So these are just a few of the kinds of cases that have been brought. And you can see here with respect to same-sex relationships that there's a kind of new sort of iron curtain, if you will, falling across Europe, right? With Western Europe really being in the vanguard on same-sex marriage and other types of partnership, and Eastern Europe being in the vanguard of the opposite range. That is to say, constitutional prohibitions, sometimes existing, sometimes new, against recognizing same-sex marriage or partnership. And in some cases, obviously, you see a kind of mix, right? No marriage, but partnership in Hungary, for example. And I think this is relevant when we talk in Q&A, perhaps, about what the reaction of states to the Inter-American Court's ruling is going to be. On transgender rights, just again, a few thumbnail sketches. The court in Europe has been quite progressive here as well. The most recent, last year, finding that sterilization or surgery is a condition of recognition of gender identity violates the convention. That was a very big victory for advocates in this area. The court has long recognized the obligation to change identity documents, and it said that trans people do have the right to marry, and they've said that 15, 16 years ago or so. So again, this is where the sort of the vanguard is, and what we might talk about is why the inter-American system might be jumping even ahead of it and what the implications of that might be. And just a very brief thumbnail sketch about the situation around the world. There is good news and there is bad news. Here is the slide with some of the good news, right? Set constitutional protection, legislative protection, judicial decisions. The decision in India, an extremely important, very broad, expansive right of privacy decision issued last year by the Indian Supreme Court, resolving some case law tensions and recognizing the rights of trans individuals as well as gay men and lesbians. That is still going to play out. India's sodomy statute has not yet been repealed, but I envision that that will happen in the not too distant future. Now, at the same time, there are, in many parts of the world, right, including the parts of the world where the de jure laws on the books are very progressive, there continue to be widespread violations of LGBTQ human rights all around the world. And I've given some examples here. And I think that's really one of the tensions that one can see, is that there's not necessarily a direct or an automatic relationship between what laws on the books are and what the lives experienced by individuals are on the ground. It tends to be the case that if you have better, more protective laws, you will have a better lived experience, but not always the case. Other examples here, you can see, and indeed, some of these provisions, some of these situations could apply right here, at home in the United States. So 2 final slides before I stop. I want to just show you a map of, I couldn't find a good map for trans rights, but with respect to homosexuality, you can see a very distinctive regionalization here, right? So Europe and the Americas, now both North and South America, largely becoming very protective, whereas Asia, and I should rule out Australia and New Zealand as well, but Asia and Africa, for the most part, very, very different, right? Including laws that actually prescribe the death penalty for engaging in consensual homosexual conduct in private. So we have a world where there's a lot of contestation, where there is a lot of pushback, and where some of the efforts to promote advocacy are get backlash, get a counter reaction. Excuse me. And just to talk about some of the ways in which these challenges are met, again, going back to the idea about there being different levels here, from the international to the transnational, regional, and local. Again, I think all of these strategies are relevant, and they exist simultaneously. They exist in different regions. Sometimes they cross between regions. If you are engaged in advocacy in the United Nations, for example. But I think it's worth keeping in mind in setting the stage for the discussion of the inter-American system that this is part of a much broader set of ongoing advocacy initiatives and opposition to those initiatives around the world. The final slide I want to show you, which will tee things up for the next part of the discussion, is very briefly, because it's kind of complicated, a primer on the structure of the inter-American human rights system. So it turns out the inter-American system has a rather unique structure in that you can be in any one of 3 tiers of membership. You can be a member of the OAS, and I'm not going to go into the details on this. I know Professor Huckerby and Professor Fujimura Fanslow will have taught some of these things in their classes. I do also in mine on human rights. So there's being a member of the OAS, in which you have some obligations, a member of the the American Convention on Human Rights, which gives you other obligations, and the highest tier, the circle in the middle, is states that have recognized the contentious jurisdiction of the Inter-American Court. There are quite a few states that have done that, but there are others at all of the different levels of membership. However, the decision that most recently came out of the court was part of the advisory opinion function of the Inter-American system, by which any member of the Organization of American States, the OAS, can ask the court for the interpretation of either the American Convention or indeed any other human rights treaty, and can also ask the court to weigh in on the compatibility of its domestic legislation or lack thereof with those treaties. And it was that request by the government of Costa Rica which triggered the recent judgment of decision, advisory opinion, I should say, let me be very clear, of the court. And with that, I will turn it over to my colleague.
Thank you.
Let's get your slides up.
So thank you very much for this invitation. I really want to thank Ali, Aya, Gustavo, Larry for making this happen. It's a pleasure to be here, but it's also a good news when more and more people are interested in what's going on in human rights. this international law in general, as you all know, does not have any police. It's not it relies on the legitimacy that comes from believing that we should use law instead of other means. And for that to happen, we need law students to also be convinced of that. As you all know, the United States has a sort of like a love-hate relationship with international law in general. And in some areas it's more hate than love, I would say, or more just like invisibility, that doesn't, ignorance, or I don't know, than anything, maybe displeasure. So the only way to change that is for you, who will be the next, batch of judges and the new generations of lawyers advocating for human rights, to be convinced that this is a good path for everyone. So I've, I have like, oh, there.
Yeah.
And how does that?
One of the up or down, I don't know which one. Yeah,
there.
Go.
Okay. So first, I'd like to say a few things about the Inter-American system and Latin America in general. And I apologize for being so short, because I always feel that, like you can see the mic instead of me. So I'll tend to move a little bit, I think. So one of the things that it's important in terms of perceptions is that we have the idea that Latin America is usually more conservative than the rest of the world. And so when things happen in Latin America that are sort of quote unquote progressive, we have sort of like a wow moment or comment. And I think that in my opinion, and as you can see from my accent, I am not from the US, I am from Latin America, I'm from Chile. And I have a different opinion about this idea of Latin America being really conservative. As a matter of fact, if you look at the history of the participation of Latin America in the creation of human rights institutions, you will see that the group of people who were, of course, also from the elites, and all white men from the elites in Latin America, who participated in the universal in the construction of the universal system of human rights, as well as in the construction of the American system of human rights, but especially, the contrast is more noticeable in the universal system of human rights, came with very much advanced ideas. So the only element that it was a little bit more progressive, for example, in terms of the protection of the family in the human rights systems in general, came from the Latin American countries, with the push for ensuring that there was equality between legitimate and illegitimate children. And that is something that you have it in the American Convention of Human Rights, and you don't have it in the International Covenant of Civil and Political Rights. You don't have it in the Universal Declaration of Human Rights, the idea that illegitimate children should be treated equally with legitimate children. It's not a lot, but I think it does sort of like sets a tone in terms of we understand reality. We understand that the world doesn't necessarily fulfill our normative ideals, that we have to also ensure the protection that comes from how the world functions, whether we like it or not. And the other example of this is sodomy statutes. So there is a huge difference between what countries had really strong sodomy statutes and what countries really didn't really penalize sodomy. And the continental legal system in general was not really prone at criminalizing sodomy conduct. And in those places where it had it, it was not really used. Whereas Anglo-Saxon countries were a little bit stronger in terms of sodomy statutes, and that you can see today the contrast between Latin America not having sodomy cases even, whereas in the English Caribbean today, the issue of sodomy, criminalization of sodomy, it's a strong problem that comes also from the inheritance from the English as being an English colony, because they have a clause in their constitution, the saving clause, that does not allow them to challenge laws that are that were stated, that were established prior to their new constitutions. So it creates this sort of like issue where they have like progressive constitutions with these really conservative statutes that they can't challenge as unconstitutional. So it's a great conundrum or problem for lawyers, because they have to be really creative. It's a horrible situation, but it creates at least discussions that are very creative with lawyers on we're going to do that, how we challenge those laws. So having said that, I am not going to also depict Latin America as a place where equality happens and everybody's happy from the beginning and what have you. As every part of the world, it's full of structural complexities that create a lot of discrimination, not only in terms of sexual orientation and gender identity, in terms of gender, and in terms of race, ethnicity, etc., as in every part of the world, I would say. The beginning of sexual orientation, so sexual orientation and gender identity are pretty new concepts. For you, are part of your normal jargon. But in 2004, when we were faced with the first case on sexual orientation before the Inter-American System of Human Rights, even when I would talk to friends and I would say, well, we're presenting a case on LGBT rights, they would say, what is that? What does that acronym stand for? No one really knew what was that. Even today, outside the crowds that are more familiar with the issues of LGBT rights, people are really confused about what is sexual orientation, what is gender identity, what is gender expression, what is intersex. It's a really confusing, these are really confusing concepts for people who are not familiar with these. Why? Because sexual diversities in general were so invisible that they didn't really exist. They didn't even make it to the legal system. It's not that there was no single case. There were a few losing cases in national jurisdictions in terms of marriage or in terms of sodomy statutes and other things, early in the 70s even. But it didn't gain momentum until, I would say, the 80s. And the issue of family law and sexual orientation didn't gain momentum until after the 2000s. So there's no country that had marriage equality before the 21st century. So marriage equality is an issue of the 21st century. In the late 20 years of the 20th century, we had some progress in terms of civil unions and recognition of same-sex families outside marriage. But it's a very new topic if you think about it. Now, add to that the T, so LGBT, and the T is sort of like piggyback riding forever into an activism that barely had anything to do with trans people. So if you think about it, the issues that trans people face every day are not necessarily very similar to the issues that gay, lesbian, and bisexual people face every day. Not even to mention intersex, which are like, so trans people are it's a tiny percentage of the population. Intersex is tinier as well. But we put them all together as, sexualities in general, LGBTI, and we keep sort of adding different numbers, different letters to this acronym. And I think that shows the reality that it's a very unfortunate acronym that doesn't really accommodate diversity of what the spectrum of sexuality is. So even though there were, so I'm going to talk now a little bit about the international systems of human rights and how these new concepts of sexual orientation and gender identity get to be discussed at international human rights levels. As Larry mentioned, these were not at the beginning of any of the systems. Nobody imagined that this was going to be a discussion that was going to happen. If you studied law in the continental legal system, you studied that the example of a void, null, completely null, or non-existent marriage was a marriage between two people of the same sex. It was just like a construction that was an impossibility. The first cases, as Larry mentioned, came from both the European System of Human Rights and the Human Rights Committee, and they were cases on sodomy. If by the 2000s, it was very clear, I would say, even though there were few cases, but it was very clear that there was a tendency already to protect sexual orientation, or at least the idea of privacy, sexual orientation within the realm of privacy, both in the European System of Human Rights and the Universal System. And in a way, those were, I wouldn't say easy cases, because there's no easy case. But it was more complicated to argue that a person does not have a right to his or her own sexuality within the realm of their own house, with no one watching, So the idea of privacy, it's simpler. But when you go to the idea of equality, things get a little bit more complicated. So for a long time, the whole aspiration was just tolerance. The idea that you just leave us alone, don't criminalize us. We are not, that type of thing. But then that is not equality. Privacy only takes you so far. But the aspiration cannot be just don't bother people in their own houses, in the confines of their bedrooms. It's got to be more in terms of inclusion. Judge Karen Atala is a judge in Chile, and she separated from her husband in 2003, I believe, or 2002. They had 3 children, all of them very, very young. And they separated when in a process of therapy, when she came to terms with her being a lesbian. They decided to separate. By then, in Chile, there was not even divorce law. So, as I said, well, it's not so conservative, but at the same time, it doesn't have divorce law, which sort of contradicts my own speech. I have an explanation for that, but I know we don't have time for that. But I stayed with my first statement that Latin America is not as conservative as you think, despite abortion laws and divorce laws and what have you. I think that there is a disconnection between the elites that rule and the rest of the population. That's, I think, what happens. So they decided to separate. The husband didn't have any problem with her keeping custody of the children because, at the same time, we have this idea of the mother as being the owner of children. So, of course, she stayed with the kids until she met another woman. She fell in love. They started a relationship, and they decided to live together. That's when the problem started, and he decided that he could not let their kids live with the mother because the kids were in danger of moral corruption. So he sought custody of the children based on the mother living with a lesbian partner. And the case was really interesting because, as I mentioned, by the early 2000s, nobody talked about gays and lesbians. There was no lesbian judge. Even till today, I think she's the only open lesbian judge in Chile. I don't think that there is any other. So it was complicated because, first of all, she thought that this is nonsense. I'm going to win the case. The kids got taken away through an injunction very early in the proceeding because the judge who took the case thought that the kids were really in moral danger. So he ordered the urgent removal of the children and put them in the custody of the father. Karen won the case in lower court, but the injunction stayed. And she won the case at the Court of Appeal level. So the decision was affirmed in Court of Appeals. There's nothing wrong with her. The kids were fine. Everybody has a right to their own sexual orientation. It was a very progressive, very, very thorough decision in the lower court that was affirmed by the Court of Appeals. But then it comes to the Supreme Court, and the Supreme Court really punishes Judge Atala for the decision of living with a lesbian partner. Interestingly, the decision was not against her being a lesbian, which in a way helped our case before the Inter-American Court, the Inter-American system as well, because the Supreme Court said there is nothing wrong. We recognize the personal right of everyone to their own sexuality, but she chose her own. She put her own desires before the needs of their children. So it's in the best interest of the children to live with the father, because she could not have. She shouldn't have been living with a woman in the same house where the children are being raised. So no problem with her being a lesbian, and this is what we argued before the Inter-American System of Human Rights. The Supreme Court created this really horrible category that was unsustainable within the Chilean legal system and within the American system of human rights. Of you had to decide, you can be a lesbian or you can be a mother, but you can't be both. That's what it's unacceptable, right? So this idea that you can be but you cannot act, that we will support status but we won't support conduct, was a huge issue that was discussed within the Inter-American system. It was a very tough case, first because it was a family case, and it's interesting. I've been talking about this case since 2004 when we took it, and the audience has changed tremendously. So at the first years, especially with American students, American law students, I would say, well, what do you think, we have a case or not? Many students would say, no, this is not a case of human rights, this is a family law case. Which would show you the divide between human rights and family law. If family law was so exceptional that you can't really apply human rights standards to a family law case, this is just a pure custody case. So if law students who are a generation, many generations probably younger than the commissioners who were going to see the case were thinking this, it was clear that we had a really challenge at the Inter-American Commission of Human Rights to win this case. So it was complicated. We had to sort of like stall the case for a little while when we thought that the commission was going to deny our case. At the end, we were able to get a favorable decision by the commission and get to the Inter-American Court of Human Rights, and we won the case. Interestingly, we won the case. We always argued only on sexual orientation. Not even once we said gender identity, because strategically we were thinking that by then we really needed to make sure that the court, first the commission and the court, understood that our argument was very, very contained. It was an argument that it was discrimination based on, first of all, it was a two-pronged argument. This was the first case. So first we had to ensure that the Inter-American Court would say that within the clause, the anti-discrimination clause of the American Convention of Human Rights, sexual orientation was included, which is not expressly included, but under any other social condition, then they would interpret sexual orientation as being part of it. So that was the first prong. And then the second prong was, we need to ensure that they understand that this particular case is a case of discrimination on the basis of sexual orientation. And that was complicated because it was a family law case. It would have been much simpler if it would have been a killing. I'm not calling for a killing, but it would have been much simpler to have a case of of violence rather than a case of family law. But as you will, if you haven't found out yet, as you will find out, we have the cases that we have, not the cases that we want to have. We have the clients that we have, not the clients that we wish we had. So we have to, deal with what we have and do the best that we have with what we have. So the case came to a surprise after 8 years of litigation. We got a favorable decision in 2012. And by then, the environment had changed. There were so many developments at national levels, so many international organizations talking about sexual orientation and gender identity. There were scholars on sexual orientation and gender identity, more than the first couple that were in the United States, but there was a movement. You could see that we had gained a momentum with the Atala case. The Atala decision comes, and it's like a domino effect. It's just incredible what happened after that. It was just that many countries started to really discuss openly marriage equality, civil unions, diverse families, etc. Different cases started to come out at local level. Colombia had like an incredible discussion. Colombia had already a huge, very rich jurisprudence from the Constitutional Court protecting sexual orientation at different levels. So the Atala case came to just like really put sort of like a real momentum of speed in Colombia. Mexico came with their marriage equality decisions not soon after, and then there were two more cases that were in the pipeline. One was Duque versus Colombia in 2016 and Flor Feria via Ecuador in 2016. Flor Feria is an interesting case because it's not really about sexual orientation. It's about to be perceived as so it's not about being or the right to be whatever sexuality category that we self-identify with, but it was more on the basis of you cannot be discriminated because you're perceived as being gay. So it's a very interesting case about Ecuador. And Flor Feria, the claimant, was like really, he himself was like, I don't want to be in this movement. He had been discriminated because he was being discriminated for being gay, but he denied being gay. So clearly he didn't want to keep being, like got into this group, like the gay group. Like, no, I don't want to be there. At the end, I think he realized that he actually was participating in a conference that was organized by Robert Whitmuth in Europe and everything. So I think at the end he came to terms with this is good. It's good that we can discuss these things. So those were the two cases. A lot of action and reaction, of course, in Latin America. At the same time, you have the discussions on abortion, and then you have the piggyback rider, which was the trans community, starts coming to the surface finally as a community of its own, as a community with its own voice. Trans people are the most marginal of the whole group. You have very few advocates because people in the trans community die very early. They die very young, not of course of genetic reasons. They die young because they are killed. They die young because they commit suicide. They die young because they are left out in the streets. They die young because they don't have access to the medical treatments that they seek. So it's very difficult to get to the point where you have advocates for the whole group. And so the movement started finally to start advocating for trans people with their own with their own identity, not piggyback riding on a larger group. And I thought when the advisory opinion was requested by Costa Rica, we thought that it was really going to be about trans rights. And actually our participation, the Center for Human Rights, we have an impact litigation project, and with that project, we had 4 students preparing a report for the Inter-American Court, acting as part of the civil society and academia groups that would participate in the hearings, and we only focused on trans rights. Why? Because trans people are dying. They need really all our attention. And from the Atala case, I focused a little bit more on the vulnerability of the most vulnerable, rather than in the. I mean, it's not that I write on marriage equality, but I was really concerned, actually, after the Atala case, that marriage equality was going to gain momentum rather than opening the door to family diversity. So for me, it was way more important to grab the pieces of the Atala decision that we could use to ensure that family diversity would keep being protected, rather than take the U.S. route, very narrow route of the U.S. of keeping the glorification of marriage as the main access to family protection. So I was concerned about this marriage, and I tried to sort of like lower the importance of that aspect of the question, and really put a lot of pressure or put a lot of thought into the trans questions. I have a few. So Costa Rica had 3 things. Well, there were 5 questions, and because you don't have access yet to the advisory opinion, I decided to bring to you the 5 questions. So I'm sorry if I hope there is no one here who is an interpreter, because you would kill me. This is really poorly translated into English. It's very literal, and I didn't have time to really review it through. Also, it's very not necessarily the best Spanish either, so I had my challenges. So, that's true. All right, so this is the first question. Considering that gender identity is a protected category, so let me give you a little bit of a background first. Costa Rica, this is a very conservative country. I think that I would say that still probably the majority is not as conservative, but the elites are really conservative. But you have a progressive government that I think that thought that this was the best strategy to advance LGBT rights. So rather than waiting for a case to advance against Costa Rica, they decided to seek an advisory opinion from the court to pose the questions that would allow then the government to have a good justification to advance on a progressive agenda in terms of LGBT rights. So with that, they would really survive. They could shield the most conservative groups, saying, well, we are really complying with the American system of human rights. That's what we're doing here. So the first thing, it's considering that gender identity is a protected category by Articles 1 and 24, and this comes directly from Atala. So the Atala and then Florfeide and Duque are the cases that say sexual orientation is a protected category. Oh, and by the way, in Atala, we did get gender identity, which
just came out of...
Yes, we're being recorded, right? So let's say that, yes, it was sexual orientation and gender identity. So a little present there. I thought that the government was going to challenge these. We were not going to say anything. No one challenged it, so we got it. Sexual orientation and gender identity. With no concept of what sexual orientation or gender identity entailed or anything. The most important part of Atala, I would say, was that it said that there was no concept of a family either, that the American Convention protected the family, but it didn't protect a particular type of family, and that was very, very important. In addition, what is stated in, well, these are the articles about equality, and Article 18 is about the right to have a name. So it says, does this protection and the American Convention of Human Rights includes the duty of the state to recognize and facilitate the change of name to persons according to the gender identity of each one of them? So the main issue was whether trans people can change their legal name. And the procedure was there, but it was a very, in many Latin American countries, I don't know how it's state by state here in the US, but it's not that simple to change your name. So also if the officer who's like taking your request doesn't like your name, I say, no, I don't like your name. So there are lots of jokes about this. In paragraph 116, you get the answer to the first question, which is the change of name. And this is where it's very interesting. And even though, and I was telling Gustavo, of course I like the advisory opinion. As an advocate of LGBT rights myself, as an human rights litigator, I like the result. Do I like the way that the Inter-American Court came up to this result? No. I think that there is a lot of flaws in the reasoning used by the court in the advisory opinion. And I think that we're living, when you have a huge action, you will have a huge reaction. So it's always both ways. And that's why we always have to be very careful how far we want to throw, because no one's going to stop the ball going very far. The problem is that the person who has the ball will throw it also very far back. So you have to be very strategic as to you want to play the game of really far throwing, or you want to go step by step, and gaining ground that way. So I think that one of the issues that you can see here is that the question was, can there be a legal change of name according to gender identity? And the answer of the court is change of the name, change of the sex in the identity card, things that no one has asked for, which I think it was a mistake by the Costa Rican government. I mean, if you want to really trigger the change, the name is not the problem. It's the sex in the identity cards what triggers the problem. If you're called Danny, or your name is Oscar, but your identity card says female, you're going to go to a female jail, not to a male jail. It doesn't matter what your name is. What matters is what the sex that has been assigned to you at birth, what will trigger a lot of legal obligations. And bear in mind that for many of you, hopefully, jail is not something that happens very often. But a group of people, especially for trans people, jail happens. So it's an actual fear. So if you tell me, well, you want to change your identity card because you may go to jail, I'm like, I'm not going to jail anytime soon. In this country, I may go because I'm Hispanic. But in my country, I'm just mainstream me. Very difficult that I would go to jail. Now, in dictatorship, that's a different story. But for lots of people, when they look at the police, they have fear. When you see a police officer, if you don't get afraid, that's because you're in the privileged group. If you look at the police and you're afraid, that means that you're not in the privileged group, that it's really complicated. So to me, the issue of human rights is to try to look at the law from the perspective of those who are afraid of the protections of the system, not from the perspective of those who are enjoying the system. So that's the perspective of human rights, in my opinion. So you see here that they went very far to say, well, not only name, but also sex, it has to be protected by Article 18. So they interpreted in a very expansive way the article. Question 2, in case of a positive answer, and you have to tell me when I stop, because I can go on and on and on. And
We
I
have until,
guess you
what,
guys
about
have
1:30?
1:30 exactly.
Yeah,
And
so
it's
we
time
really-
for questions.
10 minutes. And
Yeah.
you guys need to have questions. So I will just really speed up.
1:45? Okay, good.
All right, so in case of a positive answer, could it be considered that as against the American Convention if a person interested in modifying her name only had access to judicial process? So it's not only that do they have access, but if we have just a process where somebody has to go in front of a judge to get a change of name based on a gender identity, is that a violation of human rights or not? And that is a very complicated issue. For those of you studying international law, you will see that it can be a clash there in terms of, well, can an international judge tell you a prima facie, without more information, whether the judicial procedure per se is it violates human rights or not? And the court talked a lot about different things and internal respect for internal legislation, et cetera, but at the end it says the states have the possibility of establishing and deciding the procedure best suited, but at the end it says, regardless of the proceeding being judicial or administrative, it must comply with this opinion. It's a long thing. So it says, well, it could be judicial, it could be administrative. But then there is Article 54 of the Costa Rican Civil Code, which is the one that the government is asking the court to interpret according to the American Convention. It says, would this be contrary to the American Convention because it's a judicial proceeding, it's not administrative? And the court goes and says, the Article 54 is compatible if the proceeding for change of the name is administrative. And the article says it's judicial. So they're saying it is compatible if it is administrative. So it's not compatible. So it's a very...
It's not very well reasoned.
Well, yes. So, and then it says, and it has to focus on self-perceived gender identity, which is what we claim when the students who went to argue before the court. The main point was, let's get out of the pathology that I can't say that in English, but you know what I'm trying to say, the medicalization of trans. So let's avoid, which is that's very pervasive throughout the United States. The need for a doctor's certificate that certifies gender dysphoria is one of the requirements in many states in order to be able to change legal name. In other, they get to even, I'm not really sure if that has changed or not, but until very recently at least, some states did require a surgical change of sex, which is really like mutilation, and in many cases is forced sterilization. So all those things we were thinking, you need to get out of there. And those are very clear that are against the American Convention of Human Rights. Question 4, considering the non-discrimination on the basis of sexual orientation as a protected category, and this is where it shifts. So question 4 and 5 are no longer about trans rights, are about same-sex couples. And it's so you had maybe, I don't know how many, I haven't checked, but I think it'll be a good exercise for you guys interested in this, to take a look at how many organizations were there advocating on behalf of trans rights and how many were there advocating on issues of same-sex marriage. But when we were there, I thought it was like very clear that there were a lot of organizations that were coming from question 4 and 5. That was really the main issue. So was there a protection on patrimonial rights? And here's again a very expansive interpretation of the question by the Inter-American Court, because Costa Rica was saying, do we have an obligation to protect the tangible economic rights that derive from having same-sex couples, together? So, a couple that gets together, they live together, they don't have, of course, a legal recognition, and they buy a house. One of them dies. What happens with those things? Do they get back to the biological family, or do they have the surviving partner can inherit or can claim his or her share, right? And so that was the question that was posed. And then the answer was really, really broad. paragraphs 175, family relations, marriage is an open concept. All family connections are protected. And paragraph 199 says, protects private and the American Convention protects private and family life that may derive from same-sex couples. It includes protection of patrimonial rights without discrimination, and the protections goes beyond patrimonial rights. It includes all the rights. And then it starts talking about what it would look like to protect same-sex couples in Latin America. So do I like it? Yes, I like it as a result. Do I like the way that they got to there? No, I don't. I think that I would have preferred to have a more, especially because I'm only giving you here the question and the answer without giving you all the information that they talk, for example, about conventions that have not been ratified by Latin American countries. They use the Yogyakarta principles. And in that, we may like it because we are in the same size, provided that maybe many of you may not be in the side. But for those who are in the side of, yes, we want to advance LGBT rights, we will take whatever. But provided this, action-reaction, I'm concerned that this feeds into the critique that the Inter-American Court is not really using international law, and it's being an activist court. And we don't want that because we don't need it. I really think that we could have argued exactly the same points based on the American Convention of Human Rights. I actually, the students came with several drafts, and their drafts had Yogyakarta principles. I'm taking them out. And I am one of the people who signed the new Yogyakarta principle. So I'm all for them. I'm not saying that they shouldn't be used. I'm just saying that when you're arguing a case, you should be very, very specific into using the sources of law that you can really use that no one will contest. So I think it's a little bit muddy in the way that it was...
Just tell them, because not all of them may know what the Yogyakarta principles are.
So the Yogyakarta principles are a set of principles, they are not laws, that were drafted. The original ones were from 2006, something like that.
Civil society.
And by civil society, they got together in Yogyakarta. And they drafted this set of principles of how human rights should be interpreted in light of sexual orientation and gender identity. Very, very, it's very well thought, but they are not law. They are, and now there is a revised version that was discussed in Geneva in 2017, and they just got out the new revised version of these principles, which is all really beautiful. I myself thought that it was really beautiful. But I am not sure that I want the Inter-American Court to be using the Yogyakarta principles in conjunction with the American Convention, because I do think that it fuels the people that would say that this is not a legitimate court. And the least that I want is that, because I do think that the court does things that are really good. And in the overall, I think that the Inter-American system, with all its flaws, has been really good for the region, regardless of lots and lots of different critiques that we should all have. And then it says, in case of affirmative answer to the prior question, is it necessary to have a legal institution that regulates links between persons of the same sex in order to the state to recognize, again, all patrimonial rights? And then the answer is just like marriage equality. It's really interesting how the jump goes like, you know what? And because the beginning was, with question 4, it's like, you could have, you could not, and it's okay, and then it's like, whatever, let's go full speed on this, and they just go all the way, and they say, states must guarantee access to all institutions already in place in their legal systems to ensure the protections of all rights of the families conformed by same-sex couples. And then they go about talking marriage equality and what have you. So it's very interesting. And then the next thing that I thought that I was a little bit disappointed with the media is that what really gained track, it was that this was the marriage equality decision of the Inter-American Court of Human Rights. And I really wanted this to be trans people have finally come to, for the first time, to the first step of equality, not gaining equality, but for the first time, we're really focusing on trans rights and legal identity and making sure that people who go to jail will not be, tortured. Those type of things, and then the marriage equality gains track into this. Then you have I have only 3 headlines The first says from La Nación, a prominent newspaper, says Inter-American Court mandates to open the gay marriage in Costa Rica. Then the same newspaper says Inter-American Court mandates 20 countries of Latin America to allow for gay marriage. And then you have the reaction. Inter-American Court intends to impose a gay agenda in Latin America. So you have there, everything is about the gay agenda. It's not about the dignity of people and, trans rights, people not going to jail, to the wrong jail, people having access to hormone treatment. And in that part, the advisory opinion is great. It talks about the need for access for procedures that are accessible to the most possible extent, free of charge. It's really thorough. But what the press did really sort of picked up on is marriage equality, which I'm not really sure, if you think about the statistics of how many people get married in Latin America, not that many, which of course I would say that people who are pro-marriage should all be pro-gay marriage because that will boost the numbers. But most people in Latin America are not, marriage is a very middle-class, upper middle-class institution. People with needs are not really thinking about getting married. It's not their priority. So to me, when this is what picks up, then we're again going back to the agenda of the middle and upper middle class people who are not the ones who need us. I'm not saying that we shouldn't be advancing in that area. I'm just saying that as long as there are people dying and being tortured and not having access to health, I wish we could really. So I wish that the marriage equality agenda would piggyback right on the trans agenda and not the other way around.
Wonderful. Thank you. So we have, for those of you who can stay, which I'm not sure everybody can, the class schedule is a little bit dicey. Questions?
I have questions.
Sorry, where? Chris, yeah.
I wanted to ask about this reaction in two phases or two aspects of it. So I don't want to put forth a narrative that you might do, but I'm interested to hear what you think of this. So a root of some ambivalence I've heard about this decision, especially in Costa Rica, is that prior to it, there was a evangelical preacher who was running for president who was polling around 1%, and after this decision, he has won the first round and appears to be receiving the backing of the two main political parties against the one.
And threatening to withdraw Costa Rica from the convention as a result of this decision.
And this year, we also have elections in Brazil, Colombia, Mexico, maybe some at that time. Chile already had them, but some other countries.
And in Chile, the right wing won, but not really on
this, right? Agenda. But so the other aspect I was interested in was this movement we're seeing around the region, and also I think in Europe a little bit of people purporting to fight, what do they call it? Gender ideology.
Which I am really thinking seriously that we should definitely embrace that there is such a thing and come up with a theory that it's more rational. Since it already got installed, then just invent one that it's really reasonable instead of that nonsense. All right, so that's my fear. Sorry, go ahead. Is that okay? So yes, the problem in Costa Rica, I wouldn't say that the advisory opinion would be the responsible for the increase in the popularity of the evangelical candidate per se, but that it really it was a good platform. It was. I think that it's clear the media was, and then the next day all the candidates were against this, the advisory opinion. All the candidates were saying that this is too much, that we are, the country that we are, that we have our culture and what have you. So that's precisely the issue that I think that maybe the advisory opinion could have been a little bit, more subtle in that sense, strategically. Now, that it's completely a matter of opinion, because this is all about what if. and we don't know. So I don't have any, this is really based only on my own opinion that can really be, any other person could have a different opinion in terms of what would have been better and that this is really good in the long run. Maybe in Brazil, the evangelical movement is gaining a lot of track. This idea of gender ideology in Latin America, which is you have pseudo philosophers and pseudo political scientists talking about gender ideology as the ideology that tries to impose sexuality as something that it's a wishy-washy category that anyone can decide what to be, and that it will affect our children, it will have an impact in our families. So it's a sort of like a witch hunt, or it's like the boogeyman is coming, something very, it's a very easy to sell idea that it's really ground on nothing. It's based on nothing. There is no data that would show, I mean, quite on the contrary, there is data to show that children raised by families of same-sex couples fare exactly the same as children raised with families of heterosexual families. So there is this reaction going on that we need to be cognizant of, and I think that, as you mentioned, the worst threat is the worst threat is the idea of withdrawal from the system.
Yeah. So I'll say a couple words. I'm very worried about the Inter-American system. I'm very worried about this particular issue. So Venezuela left the Inter-American system in 2013, not over this issue. Trinidad and Tobago withdrew from the American Convention in 1998 over a dispute about the death penalty. And I think the system is more fragile than it has been at any time since when the system really had military dictatorships in the 70s and early 80s. That was a time when the support came from the United States, surprisingly, was able to use this leverage when it sometimes needed to, but the system itself managed to survive. I'm really worried about the system. I don't understand why the judges are being so expansionist. I understand that they can respond to questions that are given to them, and you have to look at understanding this is an advisory opinion, so in a formal way, it's not a binding judgment on Costa Rica or any of the other states in the Americas. But at the same time, in this decision, the court has also adopted a doctrine called conventionality control, which essentially says to all of the national courts and national legislatures, national administrative agencies, you are enforcers of inter-American human rights law, and you must interpret the inter-American human rights to give them effect as we interpret them, right? So what we interpret becomes what you have to interpret. And they have not gotten buy-in for that, I think from some national courts, yes, but not from others. Mexico, yes. Colombia, yes. But some not.
Argentina has this dual thing.
Well, and Argentina, nullified a judgment not long ago. They refused to enforce it. So, right. And so I'm really worried. I'm not sure what's happening in San Jose, which is where the Inter-American Court sits. I'm not sure what the 7 judges are thinking, but I think this is a very, very significant threat to the system. I also think that facts, although of course I agree with what's been said on I think facts, in our current situation can be manipulated in a variety of ways to achieve political backlash. And if this candidate wins and wins on the issue of, anti-marriage equality, it's a very simple thing to withdraw from the convention. And certainly the United States is not going to step up and pressure Costa Rica to do anything. So I'm worried about it.
And just to add one more thing. Oh, no, go ahead and ask because
if there is another,
Can I just ask about, you mentioned there was a domino effect following ACHR in Mexico and Colombia and other countries. I was just wondering, did they reference it specifically, the courts?
They did.
Oh, yes.
Okay.
Yeah, so the ACHR case has been referenced by local courts over and over. So that has been great. So the ACHR has a really good domino effect in that sense.
But part of the difference was, I agree with the strategy. It was a narrow opinion. It did just what it had to do. Now, okay, the court threw a few little things in about, but for the most part, it was a sympathetic case. It was one that the original first instance and second instance courts favored. Even Chile, I think at that point was not really defending it quite so hard as they were, looking for, sometimes you hear about this sort of two-level game where you can, we have to do this because the Inter-American Court tells us to do it. But that's only works so long as the institution has a certain kind of authority and legitimacy. So on that narrow issue, they were able to make it was the right move at the right time in an incremental way. This is a massive move forward, and I don't understand. This was my question. Is Costa Rica asked all 5 questions? No.
Yeah.
So I wish they had only asked the first 3.
That's what I'm saying. That's why I'm saying it's like, why do you have to ask?
I'll tell you why I think that is because the outgoing regime, which is more progressive, this was the last opportunity for them to do it, and they thought they would go for everything, and then the court responded to that by going even bigger than the government.
I think it's really interesting. It's a concurring opinion by Judge Vio, and it's dissent in the points 4 and 5. And what it's hard for me to say that I'm agreeing with Judge Vio, but in these issues. But I have to admit that I do worry about this lack of precision in the use of sources of law, which is one of the points of Vio, that sort of creates a space for critique that we don't really need as well. The other point is that it is an advisory opinion, and yet many scholars are commenting that this is mandatory for everyone in Latin America, that the court has spoken and that we all have to now change our laws. And the narrative of the court itself, it's very mandated. It's like, it's very imperative. The narrative is a very normative narrative when it's an advisory opinion. So if you look at the advisory opinions, prior advisory opinions from the 80s, it's a completely different language there that I think that we have to be careful. So again, as I told Gustavo when I first got here, there are decisions that we like and there are good decisions. There are decisions that we don't like and there are bad decisions, and they are not exactly the same. Right. A good decision is a decision that we can use in the future. We may disagree with the outcome or we may like the outcome, but that has nothing to do with whether it's a good or a bad decision. And then you have decisions that are really bad, but you really like the outcome. So, and that of course creates a complication of how you critique the decision, because you want the outcome to stay, but you don't want the reasoning to.
So Christine, I predict that you are going to see a counter move on this judgment. I think you will see national courts cite it, and I think they will say, we disagree, and we're not going in that direction. I think there is enough precedent. The Argentina Supreme Court has said on an issue of, retroactive prosecutions, they've said, no, this goes too far. The Venezuelan courts before the withdrawal refused to give effect to the Inter-American judgment. There have been signs for a long time, and for whatever reason, in San Jose and in Washington, where the commission sits, they are not hearing these signs, and I think it's very dangerous.
Now, if I have said, though, the other side, Panama, they have a pending marriage equality decision before the Supreme Court, and I was exchanging emails with the lawyer who's taking this case, and he told me that the government had submitted a brief against the case, and after the advisory opinion, it withdrew it. Withdrew it because of the advisory opinion. Right. So, at the same time, we have these things there.
If that happens, then I'm happy to be proved wrong. I'm completely happy to be proved wrong.
We're on the same page.
Any one last? Yeah.
I have a question, especially given sort of how, as you said, expansive this advisory opinion is, and also the great diversity within the region of the Americas in terms of laws on same-sex marriage and transgender rights. Is there anything in the opinion that allows for sort of more progressive realization or includes any sort of benchmarks, particularly given how diverse the region is with these issues?
So the narrative is very straightforward, and it's interesting because it has that some of the paragraphs are very sort of conciliatory. This is an advisory opinion, may or may not. But then when the answer comes, it's a very straightforward. This is what it has to be done. So it doesn't leave much space there for there is one thing in terms of marriage equality where it says something that I interpret as like if you can't do this now because you have structural obstacles, then you can have a transitory, a temporary system, but that system anyway has to give the same rights to same-sex couples, which I interpret as if you don't have marriage equality, you still like the Oliari case.
You need civil union,
Yes,
or you need registered partnership.
Exactly. That's how I interpret it. It's like you have to have something similar to marriage, but marriage is the aspiration.
I think we are out of time. Thank you very much for attending.
Thank you.
It was very interesting.
Sorry, 1 second.
Yes.
Let's do it.
Yeah, that's perfect.
I'll email you later.
If that would happen,
Yeah.
the